Thank you all so much for coming to tonight's talk. My name is Uglješa Grušić. I'm a professor of private international law here in the faculty, and it is my great pleasure to introduce tonight's talk entitled Muscles from Brussels. Now, obviously, if you came here expecting to see Jean-Claude Van Damme, I'm very sorry to disappoint, but we do have another distinguished Belgian with us tonight, Professor Van Kalster, who is a full professor at the University of Leuven in Belgium, where he does a lot of things. He specializes in private international law, arbitration, international and EU economic law, as well as climate change law and environmental law. And he's also a head of Department of International Law and EU Law at the university. He is also a distinguished legal practitioner at the Belgian bar, and his expertise basically and practice covers all these different fields. But interestingly, he occasionally comes across the channel to visit us here. So I had the distinct pleasure of advising a client here in the UK, and that was a very interesting case and an unforgettable experience. But also, he is a prolific author and a prolific blogger. So if you visit his blog, you'll basically see that he reports on a lot of current developments, not only about Belgian law or European law, but also about English law, and does make one wonder, where do you find time for all of that? Because I think it's difficult for us who are only doing private international law, mainly private international law, to keep up with things and the pace of developments. Anyway, tonight you will give a talk on Muscles from Brussels, if I understand correctly, essentially about the extraterritorial application of different EU laws, whether extraterritorial reach of EU laws is a good idea, whether it works, and so on. We are very grateful to have you here tonight with us. Thank you so much for coming, and yes, look forward to your talk. Our speaker will speak for around 40 minutes, so that will leave us around 20 minutes for Q&A.
Thank you very much. My late grandfather used to, father-in-law used to often talk about death by PowerPoint in all sorts of meetings. So I've decided not to use PowerPoint tonight. And instead, I've actually prepared a talk, old style. Dear Professor Grušić, dear colleagues, dear students, thank you very much, Uglješa, for inviting me to give this talk on what indeed I coined Muscles from Brussels. GCVD, I think our children would call Jean-Claude Van Damme. In the announcement for the talk, I evoked the theme of the EU flexing its muscles. Those of you who follow my work, potentially via the blog, and thank you for those comments. One of the answers to how do you find the time is I do sneak away at weekends and read judgments on my laptop in the cellar, where my family then find me hiding from other stuff going on. So those of you who follow my work know that in my view, the EU currently employs an incoherent dispute resolution spider web that is supposed to discipline EU law. The European Court of Justice's relationship with investment arbitration is troubled. Our host tonight knows a lot more about that than I do. But also its approach towards commercial arbitration is, even if it's warmer, it is still, I find, incoherent. And that topic of regulatory flexing, the muscles from Brussels, accompanied by incoherent litigation mechanisms, may or may not be the core themes of my current sabbatical. This is my first sabbatical in 23 years of being a professor of law. So I have, I would submit, earned the privilege of my mind being a little bit all over the place at the moment. I should like to take the opportunity, I'm sure Professor Grušić will not be offended. I should like to take the opportunity to thank the fellows of St. Catherine's College, Oxford, and Professor Andrew Dickinson in particular for hosting me at Oxford this term. The college's intellectual and certainly also catering environment greatly facilitate my cerebral maelstrom. The consumption of brandy apparently in the senior common room at St. Cat's has gone up since I've been at the college. Nothing to do with me, of course. I also want to thank University College London, British Branch of International Law Association, and its representative, Professor Grusic, for hosting me today. I know all too well that us as academics are somewhat overwhelmed by teaching, service, and research. The meeting of minds suffers very much from the indigestion of other types of meetings. And I'm grateful to Uglesha that he is steadfast in his dedication to intellectual debate. And I would like to thank you all for being here tonight, rather than seeing the wonderful, if early, Christmas decoration in London. When I was at the College of Europe, now I'm going to sound like an old man. When I was at the College of Europe, promotion Stefan Zweig, academic year 1993-94, we danced to the 30-year reunion a couple of months back. The Treaty of Maastricht came into effect. So when you're Dutch speaker, you have about 3 advantages in life. You can pronounce Maastricht, you can pronounce Van Gent and Loos, and you can also say Kevin De Bruyne, as it should be said. That's more or less where the advantages stop. So the Maastricht Treaty entered into force 4 years after the fall of the Berlin Wall. The college opened its Natolin campus, that's in Poland, while we were at Bruges. And indeed, Poland, and with it a range of other Eastern European countries, were on course to join the EU. The WTO agreement was being negotiated to begin its life on the 1st of January 1995. The Cold War was in its dying stages. The Soviet Union had been dissolved, communism had failed, and its imperial ambitions seemed to die together with the Soviet Union. We as students then did not look upon that with much glee. As young Europeans, even younger than we are today, we knew there was a big task ahead to rebuild a peaceful and prosperous continent. We did, however, look confidently to the future, because this new world order was to be based on what we now nostalgically call the rules-based international order. We literally had one student among us who talked about a lot of geopolitics. He was a Frenchman. He still is a Frenchman. In spring, he was a good late-night companion on the terraces of Bruges. We did not take his geopolitics very seriously. I'm not sure whether he did. I think he probably did, actually. 30 years later, those talks have come back with a vengeance. In her 17th of September 2024 so-called mission letter to Kaja Kallas, since last Sunday, EU High Representative for Foreign Affairs and Security Policy, European Commission President Ursula von der Leyen mandates her, among others, to, quote, shape a new foreign economic policy, focusing on economic security and statecraft, free and fair trade, and investing in mutually beneficial partnerships around the world, notably through Global Gateway and more strategic use of our external financial instruments, unquote. And Kallas is also asked by von der Leyen to, quote, contribute to the work of developing a new economic security doctrine, end of quote. The German 2023 National Security Strategy states, bit for the Germans here, in Zukunft werden wir Sicherheitspolitik stärker mitdenken bei wirtschaftspolitischen Entscheidungen, which is best translated, I think, that security considerations will be integrated into foreign economic policy decisions. The integration principle is something which environmentalists in the room will appreciate. In a June 2024 speech, Mario Draghi accepted the Charles Holy Roman Empire Prize. This is Charles I, I think, to the Spanish, and Charles V to the rest of Europe. His acceptance speech was a sneak preview of the September 2024 Future of European Competitiveness report, the Draghi report. And that June speech oozes geopolitics. Quote, the paradigm which brought us prosperity in the past was designed for a world of geopolitical stability, which meant that national security considerations played little role in economic decisions. But geopolitical relations are now deteriorating, end of quote. And he also said, quote, we'll need to develop a genuine foreign economic policy, or as it is called today, statecraft, that coordinates preferential trade agreements and direct investments with resource-rich nations, the building up of stockpiles in selected critical areas, and the creation of industrial partnerships to secure the supply chain of key technologies. And in relation to international trade, Dr. Draghi mentioned that the paradigm which brought us prosperity in the past was also one in which world trade was governed by multilateral rules. But these rules are now becoming less and less binding, and the largest economies are increasingly operating unilaterally. As an aside, by the way, those of you who are environmental lawyers should read the Draghi paper with some attention, given its techno-optimism, its support for the phantom innovation principle, and its pushback against established environmental principles like precaution. And completely unrelated, Dr. Draghi's MIT PhD, 1973, I think, was titled Essays on Economic Theory and Applications. And that's what it was, 3 essays on unrelated economic ideas. It's something that I noted because I thought one or two of my PhD students, I think I would like to give the freedom to just do that, write 3 essays on unrelated stuff without methodology, etc. But I'm really straying now, so I should go back to these quotes. So I could give you a long list of quotes from world leaders and others who observe the return of geopolitics as a key driver for international relations. I will end those quotes with one by ECB, European Central Bank, and former IMF managing director, as well as, by the way, former Baker McKenzie chair, Christine Lagarde, from an interview with the Financial Times last week, when she was asked how the EU should respond to the imminent so-called Trump tariffs. And she said, we seem to err more on what I would call a checkbook strategy. We could offer to buy certain things from the United States and signal that we are prepared to sit at the table, see how we can work together. I think this is a better scenario than a pure retaliation strategy, which can lead to a tit-for-tat process where no one is really a winner. I'm, of course, aware that before these suggestions of pandering to unilateralism by other states, we should sort of sit down, negotiate, and in this case, buy American. I'm aware that the WTO dispute settlement system, of course, has always been about that, settling the dispute, preferably before panels are convened. I'm also aware that such settlement has in the past not always entirely taken place in a spirit of compliance with substantive WTO law. There's also those who hope that internally US law might give the US president a lot less power than perhaps might be hoped. I think that's vain hope, because there's many rules of presidential authority in the United States, many of them dating back to the 1930s Great Depression, which give the administration precisely this kind of power. And it's also clear that the Trump 1 administration was not shying away from weaponizing these powers. It's also clear that a new series of Trump tariffs are vulnerable under WTO law. National security clucks on here for the WTO lawyers amongst us. The WTO has in fact ruled against US steel and aluminium tariffs imposed on China, a ruling which is ironically under appeal by the United States with the WTO appellate body, the very body that has ceased functioning following US obstruction in populating it with the required appeal judges. However, the vulnerability of the tariffs under WTO law has clearly not impressed the incoming US president, who is likely, to paraphrase Stephen Bannon, to flood this zone with tariffs. Even if WTO members were to challenge those incoming tariffs under WTO law, and comments like Christine Lagarde's, I think, make that actually unlikely, the organization is unlikely quickly to be able to cope with them. Let me repeat 2 of Dr. Draghi's comments in his speech accepting the Charles V Award. Firstly, his multilateral trade rules are becoming less and less binding. He is, of course, incorrect. Their binding nature has not changed. Their enforcement has. Further, Dr. Draghi mentioned we'll need to develop geopolitical statecraft. And in his eventual report, he mentions geopolitics no less than 24 times. In the past, free trade arguably was the EU's external economic policy. The EU project literally established internal peace by creating economic interdependence, and it had the ambition to repeat that trick on the global stage. In the current climate, geopolitics would seem to demand free trade be only one and not the most immediately obvious objective of EU statecraft, as Dr. Draghi called it. And that brings me to the announced topic of today's talk, muscles from Brussels. And I used two examples in that summary for the talk. The first one is a recent update of the EU's trade defense instruments as an indication of the apparent EU willingness more aggressively to protect its industries from what it argues is unfair foreign competition. And the second one is the intensive rollout of laws in the business and human rights sphere, including environment. Let's look first at trade defense instruments. This, if you like, upgrade, TDI, Trade Defense Instruments 2.0, in the EU predates both the recent US presidential elections and the fashionable use of geopolitics in the vocabulary of today's international relations. Broadly speaking, TDIs are part and parcel of the WTO legal regime. They protect WTO members against unfair trade practices. They are anti-dumping measures, anti-subsidy or countervailing measures, and finally, safeguard measures. These can be deployed temporarily to address unexpected surges in import, which might restrict or injure domestic industries. TDIs restrict international trade. They address what is seen as unfair ways to get ahead in the comparative advantage game, which to this day underpins the World Trade Organization. For the longest time, they were considered the domain of geeky trade economists and greedy Brussels, Washington, or Geneva-based trade lawyers. Most trade lawyers, by the way, TDIs are also their first encounter with the devil's invention, not PowerPoint, but the Excel sheet, which I know many lawyers struggle with. I, to this day, remembered in a meeting on my first anti-dumping case, which was on Coke 80+, not the illegal substance, but the carbon steel instrument, where in the meeting I discovered that Excel sheets have more than one page. This was in the mid-1990s. So if you didn't know that, you will not confess to it, I'm sure, out in the open, but remember me when tonight you rush to your Excel sheets and realize there's much more on them than perhaps you had thought. In the EU, the frank politicization of TDIs arguably started not so much with the 2018 EU safeguards imposed on US steel, following the Trump administration's Section 232 measures on EU steel and aluminium, because that 2018 EU measure could still be seen as a simple technical application of the rules. Rather, it is the Biden administration's Inflation Reduction Act, which to any, I think, UK ear was still oddly sound or referred to as the IRA Act, particularly its green energy provisions. These prompted the European Commission in February 2023 to announce the use of TDIs to shore up what it's called its Green Deal industrial plan, which culminated for the time being in the EU's anti-subsidy investigation into Chinese electric vehicles. For non-trade lawyers, typically an anti-subsidy investigation suggests a much lesser sanction than an anti-dumping investigation. So it's in itself quite interesting that it should not have been anti-dumping, but rather anti-subsidy. And the revamp of the EU's TDIs is also a core background to the June 2023 European Economic Security Strategy. But if you think back at the birth of the resort of TDIs as an instrument of foreign policy, then I think we arguably need to go to the 2020 initiation of Chinese anti-dumping and countervailing measures on, amongst others, Australian barley and wine in response to Australian measures during the COVID pandemic. As for content, the EU's modernization of its TDIs relates, first of all, to new methodologies in calculating dumping margins in the event the exporting country practices what are called distortive economic policies. Also, new ways properly to gauge and manage the impact on raw material flows when it comes to anti-dumping investigations. And finally, the adoption of an anti-coercion regulation, an ACI, anti-coercion instrument. This is aimed at events where, and this is the definition in the regulation, I quote, an anti-coercion is where a third country applies or threatens to apply a third country measure affecting trade or investment in order to prevent or obtain the cessation, modification, or adoption of a particular act by the Union or a member state, thereby interfering in the legitimate sovereign choices of the Union or a member state. This, of course, very, very clearly echoes the use of investment law as a way to coerce countries into typically scaling back regulatory ambitions, be it in environment, public health, or any other sector. Overall, if you think of the trigger of this series of updates to the EU's EDIs, then I think it's largely to keep up with the US, the Chinese, and other Joneses. And importantly, even if not necessarily designed to do so, it inevitably leads to much more focus on what is called inshoring, self-sufficiency in critical industrial sectors, in line with, amongst others, the EU's Critical Raw Materials Act. Notice how by making TDIs more political, inevitably, those civil servants leading the investigations and the customs officials enforcing them have become explicit agents of political change. Over and above their role in TDIs, this altogether small, or at least concise, group of trade officials has to continue to negotiate free trade agreements, has to continue to engage in more targeted sectoral agreements, such as the digital trade agreements with Singapore and South Korea, also has to engage with the course on data flows with Japan, and with the continuing, if arguably very lame, talks at the WTO in furthering the WTO agenda. All of this was also emphasized by Trade Director General Sabine Weyand in a speech in Brussels in May 2024. And here we come to a link with the second part of the blurb for tonight's evening, and so also certainly the second part of my talk. Namely, as far as the enforcement of all these measures is concerned, the EU is dependent on the customs officials of the member states. CBAM, that's the Carbon Border Adjustment Mechanism, which I'll get back to later, but also other instruments such as the Deforestation Regulation, specifically address the risk of circumvention. And of course, in practice, certain high-risk industries may well be tempted to resort to arbitrage or forum shopping when importing into the EU. All of this suggests we ought to develop a greater sense of urgency in addressing the amount and the training of customs officials tasked, tasked with the implementation of these laws. Professor Joost Pauwelyn, incidentally, has a great article on that, customs officials' duties and arbitrage in CBAM and also in biofuels. Customs officials, therefore, play an equally important role in the second part of today's talk, and that's the rollout of territorially extended laws in the business and human rights sphere. Professor Joanne Scott, correctly in my opinion, has advocated against the intuitive reaction to call this indeed extraterritorial laws. Instead, she calls it territorial extension. And to cite her, the EU seeks to galvanize third country or global action to tackle transboundary problems and to pursue objectives that have been internationally agreed upon. The flagship regulation here, of course, is the Carbon Border Adjustment Mechanism, CBAM. It is, however, by no means the oldest European law which aims to kill the two birds of ensuring a level playing field between EU industries that are made subject to environment, employment, and other sustainable development laws, and also generally promoting those goals through trade. One of the oldest such instruments, arguably, is the 1991 leg hold trap regulation, which bans the use and extends the ban of these leg hold traps that catch animals, as the name would suggest, by simply holding their leg in this trap, where they eventually, over the course of a couple of days, die. The introduction of this regulation led to a lot of noise on WTO compatibility, and eventually it led to the introduction of internationally agreed, quote, humane trapping standards, unquote. Some of you might find that a bit of an oxymoron when you think of the title. Internationally, in this instance, really affects a small number of states only, for whom the trade implications of the mooted EU import ban was the most immediately relevant. Canada, Russia, Turkey, and somewhat bizarrely, Jordan. Still not quite sure where how Jordan became to be impacted. The United States have a related but diplomatically different agreed minute with the EU. Bit of a quirky instrument of public international law. Now, these trapping standards are still in force, and crucially, their enforcement is entirely outsourced to the home state where the animals are caught. The exporting states, including the EU, designate a limited number of authorities competent to issue certificates of origin, and these do no more than what they say in their title. They testify that the fur from the animal caught in a trap originates from their soil. They do not, as such, testify that specific fur as having been caught in the prescribed human way. That is assumed, that enforcement is assumed to have happened through the implementation of the agreement. If you look at this with 2024 eyes, you would argue it's extraordinarily naive. But of course, in 1991, it was seen as a great way forward. And as I mentioned, the agreement is still in force. The leg hold trap regulation was adopted a few months after the first tuna dolphin report at the GATT, as it was then still called, in 1991. That report, now this was a pivotal moment for the kind of regulatory standards that we talk about today. This report, in 1991, torpedoed the US argument that an extension of domestic regulatory requirement, in that case, fishing techniques, when fishing for tuna, designed to avoid the incidental killing of dolphins, the US argued that extending that domestic regime to imported products was simply what I tend to call a border regulatory adjustment. We impose it upon our domestic industries. Surely we ought to be within our rights to impose it upon imported products. But the panel disagreed. And from that moment, what we now call NPR PPMs, non-product related production processes and methods, any regulatory decision which distinguishes between products on the basis of characteristics not included in the final product itself, those have become very suspicious under WTO law. Incidentally, the panel referred to what is known as the Border Tax Adjustment Report and Practice in the GATT, which is very much an established principle of international tax law. Those of you familiar with WTO law know that this has had a massive impact from the moment you are thinking, again, an echo here of investment law, from the moment you are suggesting you will use a measure by which you extend your NPR, PPM-based domestic laws on imported products, the WTO flag will go up, much as the investment law flag might go up, and there'll be a whole lot of spiel about you having to scale back your ambitions in those laws. It makes indeed for very fertile ground for opponents of those laws to try and what is called freeze such proactive regulation. And it's also true, in my view, that WTO dispute settlement has not helped these states thinking of imposing these rules in clearly outlining how they might be able to get away with those rules under the exceptions regimes of the World Trade Organization. The pace of adopting EU laws aimed at inserting sustainable development concerns into global value chains has, of course, increased in recent years. As recently as the 19th of November, a couple of weeks ago, the EU adopted the Forced Labour Regulation, which is now awaiting publication in the official journal. It complements member states' legislation on forced labour and EU frameworks, including the equally recent Corporate Sustainability Due Diligence Directive, the CS3D. The Forced Labour Regulation joins other such initiatives, in particular, interestingly, the long US history of such measures. The United States have had forced labour import ban regulations since 1929. Again, one of those Great Depression moments. Between 2001 and 2015, not a single ban was enforced under Section 307, but then in the Trump one and the Biden administration, more than 40 such bans were imposed, coming on top, by the way, of other measures such as the Xinjiang Uyghur Autonomous Region Act in 2021. The CSDDD, the Corporate Sustainability Due Diligence Directive, also recently adopted, arguably applies as lex generalis vis-à-vis more specific initiatives. The point of the CS3D is that you impose corporations, those domiciled in the EU, others with turnover in the EU, and also a small set of very sensitive sectors, including diamonds, for instance, that you force them to exercise due diligence in their entire supply chain, even in the absence of contractual relations with corporations further down in that supply chain. But it's not the only instrument. Excuse me. The EU's deforestation regulation, I mentioned that earlier, 2023-1115. This requires companies trading in cattle, cocoa, coffee, oil palm, rubber, soya, and wood, as well as products derived from these commodities, to conduct extensive diligence on their value chain, including, by the way, indigenous rights due diligence. There's the EU blood diamonds regulation, which is meant to facilitate the Kimberley process on blood diamonds. The EU cosmetics regulation, building upon a cosmetics directive equally contested at the time as the leg hole trap regulation. This EU cosmetics regulation bans most of animal testing, and it applies to finished products and ingredients anywhere in the world. There's also, as a specific example, in the environmental sector, the EU ship recycling regulation, 1257/2013. I will put up this talk, by the way, on the aforementioned blog. For those of you lost in numbers, I should have said this earlier, but it'll be good practice to the students in the room writing this all down, because assuming you still have written exams on campus, that's what you need to do. Many students fail because they get cramp. At least that's what one or two of our children have mentioned when they failed an exam. It's good practice, but yes, I will put this up. So the EU ship recycling regulation applies to ships that fly the flag of an EU member state, and certain of its rules, particularly on hazardous waste, also applies to non-EU ships that call at an EU port. Now, for the idea of sustainable ships recycling. The EU does not ban ships from being recycled outside of the EU, but it adopts a list of approved facilities for which it relies on, intra-EU, it relies on European Commission inspections. Outside of the EU, it relies on external audits, and I'll get back to audits very shortly. There's no better example for the challenges in introducing this type of regulation than, again, the CBAM. The Carbon Border Adjustment Mechanism imposes a carbon price via the purchase of certificates. Any carbon prices already paid in the country of origin will feed into these certificates that you need to acquire in the EU, and those countries with an emission trading system similar to the EU's and linked to it via a public international law agreement are exempt or will be exempt from CBAM. CBAM is in force but not yet applied as far as the certificates are concerned. That will happen at a later stage. It's a clear objective of the EU CBAM to have exporting nations adopt an EU-like carbon pricing mechanism. That's the Brussels effect squared, if you like. I suspect you'll be familiar with the Brussels effect, the idea that by default, exporting nations to the EU will adopt EU-style regulations in order to safeguard their exports to the EU and protect their exporters. That's the Brussels effect, entirely voluntary. CBAM, I would suggest, has this Brussels effect squared because, of course, it encourages those exporting nations to adopt a similar kind of law. Now, importantly, there's a very complex follow-up machinery of Commission and Council, European Parliament regulations, which has created the backroom machinery that is needed to feed both real and guesstimated data on emission of production processes outside of the EU, because you need to know, in order to know how many certificates you need to surrender, purchase and surrender, you need to know how carbon friendly or unfriendly the production process is. James Flatt, who's a trade official and one of the CBAM's principal architects, put it as follows, and I'll quote him on how he views the mechanism, but it's important you keep in mind that CBAM was opposed for 10, 15, 20 years before it finally came onto the statute books. That's the WTO flag that kept on being waved in the background. So James argues the CBAM is a transnational governance instrument whose time has come. The decoupling of past and future responsibilities for climate change, environmental lawyers will know this as a principle of a shared responsibility, common but differentiated responsibility in climate change. So James argues the decoupling of past and future responsibilities for climate change may be politically controversial, but it is legally permissible. And the only rational decision at this point is CBAM. It is particular because credit is given for any carbon price paid in the third country, and this is central to establishing its exclusively environmental credentials and to understanding the regulatory nudge created by it. An indirect tax based on the destination principle would not have this effect. That's important because in the 1990s, both the EU and the United States had developed draft carbon and energy taxation, which would have applied a carbon border adjustment mechanism, but only for the tax part and not with the incentive. The unilateral initiatives which I flagged here operate alongside the EU's drive to continue to insert trade and development concerns into FTAs, free trade agreements, including in the more advanced forms of the EU-South Korea FTA. Interesting developments this afternoon in South Korea, given the democracy, social rights, etc. provisions in that FTA. There's also provisions like that in CETA, and of course, as you might know, in the EU-UK or UK-EU Trade and Cooperation Agreement with its level playing field mechanism. Overall, initiatives like CS3D provoke a continuing market for assistance with the setup of due diligence process. So this is where the reports come in, the preparations, the reports, the negotiations with shareholders, and so on. All of this needs to be set up. All of this needs to be audited. All of this needs to be certified. Those of you who, like me, have worked on the flexible mechanisms for greenhouse gas emissions under the Kyoto Protocol will share my experience and perhaps expectation that this is a market where arbitrage and gaming is rife and where not unfrequently, outright corruption occurs. And that's a reality I think we must face. The aforementioned ship recycling regulation is also a good example for those wishing to look at these territorial extensions, but they are easily circumvented. A Commission study, 2017, showed that although 40% of the world's ships at the time were owned by EU corporations, only 20% of them flew an EU flag, and that number dropped to 8% once the ship became end of life. That's a regulation which is easily circumvented, and I don't think that the Hong Kong Convention on Ship Recycling, which will enter into force in June 2025, will have much of an impact on that. I should also, by the way, add at this point, I will become more optimistic later. I should add at this point that, of course, we are, whilst we are trying to address how we produce, and might, I think, do that somewhat successfully, we are failing miserably to tackle one of the root causes of the triple planetary crisis, which is overproduction and overconsumption. The failure to agree production limits, even in the example of plastics, for instance, both at the EU and the international level, is not an encouraging sign. And some of you may have read on the outcome of the plastics treaty negotiations just this past weekend. Now, this is where we just noted the difficulty in enforcing those regulations, but where we come at the important juncture of private enforcement or due diligence-related private actions. And sticking with this example of ship recycling and end-of-life ships, in March 2021, the Court of Appeal for England and Wales, in a case called Begum and Maran, held that it is not fanciful, Begum and Maran, for those wanting to write that down, 2021 Court of Appeal. The court held that it is not fanciful to accept a duty of care for global value chains upon an England-based initial owner of a ship who could foresee that it would be beached in dangerous employment and environmental conditions in Bangladesh. Lord Justice Coulson, in that appeal, held on a strikeout and reverse summary application. So you need to be a little bit careful when you read the judgment. The Court of Appeal has not held that there is such duty of care. It has held that it is not fanciful, that it can be argued that there should be such a duty of care. What happens next typically is that the case goes back to the High Court for trial on the merits and that the parties settle. That also happened in this case. These kinds of judgments, in my view, are a very strong compagnon de route for the many regulatory initiatives on the global value chain. And they usually do not even have to take the route of what is called strategic and public interest litigation, which, of course, in climate change is very rife at the moment. It's a judicial route applauded by NGOs for its filling in the many gaps in government regulation, but it is vilified by those accusing lawyers of being activist and of betraying separations of power. That, in my view, will be the same with the CSDDD. Its civil liability provisions only apply where the claimant can show that the damage arose directly from a neglected duty under the directive. That's a high causational bar to prove. Opponents of the directive already suggest that all it will do is feed consultants, auditors, and certifiers. But in my view, and I'm coming to a conclusion, in my view, regardless of whether compliance will, in and of itself, deliver greater sustainability, the directive at any rate will be of great assistance in providing claimants who are often based outside the EU with a paper trail of due diligence and its opposite, carelessness, when suing for climate, environmental, human rights, workers' exploitation, suing in the EU, even if those events and the damage took place outside of the EU. even if those claims do not directly come within the scope of the CSDDD, the directive, in my view, will assist greatly with the preparation and successful bringing of such claims, including in countries like the United Kingdom, clearly not bound by the CSDDD. I want to signal here the excellent book by Dr. Ekaterina Ristova, and I'm very pleased she's here, on tort litigation against transnational corporations. This was recently published with Oxford University Press. It discusses these kinds of claims in both legal detail and, interestingly, in questions of suitability, seen, for instance, through the lens of TWAIL, which I think you might know stands for Third World Approaches to International Law. I note, and this may be of interest to private international lawyers, this is a bit of a pudding for our chair, that the CSDDD in this respect may act as a necessary trigger for the European Commission actively to consider harmonization of jurisdictional rules for non-EU based defendants. The upcoming review of the Brussels 1A regulation would, in my view, be a good opportunity for that. So I should explain, for those of you, excuse me, mistakenly not versed in private international law, it is really easy to sue an EU-based defendant in the EU that is similar-ish for the United Kingdom. But when it comes to non-EU defendants, either as the main defendant or as a side defendant, the rules are not harmonized. So here you get application of national rules that can differ greatly across the many jurisdictions. And there, of course, you then get forum shopping, you get all sorts of engineering of claims so as to end up in an interesting jurisdiction rather than an uninteresting one. And it would be useful were the Commission to propose to harmonize these rules, because that, I think, would also help in harmonizing implementation of instruments like the CSDDD. Let me conclude. In this talk, I have signaled two important domains where the EU has been flexing its muscles. First, a polished set of trade defense instruments, and an increasing amount of instances, secondly, where the EU territorially extends its laws. Neither of these developments were immediately triggered by this summer's strong emphasis on geopolitics, which I flagged at the beginning of this talk. Yet they clearly take on increased resonance now that geopolitics is a talk of town. In theory, the EU has a good phalanx of trade and regulatory instruments which may underpin its economic, industrial, and sustainable development objectives. But in practice, much of their impact will depend on their enforcement, for which we need to look at, firstly, customs officials, with now much broader tasks than the traditional customs and tax classifications. Secondly, a dedicated but quantitatively limited group of trade officials, and importantly, a growing number of private interest and public interest litigation. If geopolitics is going to be the game, then the EU had better make sure to be good at it, probably with more aggression than we as Europeans usually like to showcase. Thank you.
Thank you so much for your talk. I have to say it's quite incredible how you managed to weave so many different fields of law into one story. It was excellent. So I believe we have around 10 minutes now for Q&A. So I will open the floor for questions.
I just wonder generally to hear your views. Do you think the law is evolving rapidly enough in all of these different areas? Of course, we've seen lots of legislative activity in relation to sustainability and climate change increasingly. We see some work, but we also see how the challenges transforming the world and COVID-19, artificial intelligence, corporate power, wars, etc. So whether law is still in pace with these developments and whether it's still for global politicians to take the probably too big to answer it.
Yeah, should you want to take more questions? Yeah.
Well, actually, I need to repeat the question for the benefit of people who are online, because we don't have a microphone, unfortunately, in the room. So the question was whether the law is evolving fast enough given all the developments that we are seeing. But maybe we can take some more questions. Maria.
You started with geopolitics, and my sense is that you think that the response to the geopolitical situation in which the EU finds itself will be trade, that trade is the response. And we also hear a lot about security, which I think aligns a little bit with your geopolitical starting point. So do you imagine trade as a response to the kind of really difficult and complicated conversations about security in the European Union? And I suppose, what does that look like? I find it hard to picture.
So the second question was about trade as a response to security and geopolitical questions.
Yeah, great questions. Let me first answer Katarina's question. My glass tends to be half full, not half empty. I do hesitate, though, to say that for climate. For climate, I am a touch concerned. For sustainable development goals generally, I do think that both regulation and litigation, the law as a whole, if you like, can have an important impact on change and can do that successfully, albeit, of course, it would leave behind those that have suffered from the environmental, etc., conditions in the past. But it's a slow process. And for climate, we don't really probably have that kind of time. And therefore, what I tend to do in climate litigation judgments is I do try and look for those types of judgment or parts of judgments which might make people in what is called the C-suite sit up. Right? So, for instance, in the recent Court of Appeal judgment in the Netherlands on the Shell ruling, where, of course, the headlines would tell you that Shell won because the ruling was reversed. In reality, there's a lot in that judgment which I'm sure the executives have noted, including the very important observation by the court that those industries that produce both processes and products which contribute more than others to climate change also bear a greater responsibility. That's great material for when you take an actual claim-based case, which sadly there's many in climate laws, and there are going to be many more, to a court against, for instance, a fossil fuel corporation. So there's certainly schnubbles in those various judgments, I think, that greatly serve subsequent cases. But for climate, it's a race. And I worry together, I suspect, with many others. I do think it's an and, but I certainly indeed do not rely on regulation alone. And I also fear, and that answers already, I think, Professor Lee's question, I also fear that amongst the current European Commission, there is not going to be the kind of appetite for new laws on global value chains, new laws on sustainability. That I don't think is going to happen. That's not necessarily a bad thing, because you've heard me list a long list of instruments which now need to be implemented and complied with. So there's plenty of stuff to get on with. But of course, when it comes to the security element, it's going to be much more focused on critical raw materials. It's going to, I mean, what Christine Lagarde said basically was buy American weapons. That's, I think, what she was saying, to appease, so, you know, appease the US defense industry, so as we can both replenish our own supplies and help, hopefully, the Ukraine in their war with Russia. It's not going to be about sort of sustainable development initiatives, clearly. But that too is and, because it is certainly the case that if you look at litigation, the market is much more mature than it was even 5 or 6 years ago. Some of that is for a scholar, but also a citizen, interesting, like litigation funding. Litigation funding mechanisms were basically I realize I'm being recorded, so I tread carefully. So where basically capitalist profits fund cases against other capitalists and what they might have done wrong, right? So ethically speaking and philosophically speaking, that's a little bit weird. But in reality, this kind of funding and the professionalism with which law firms both have responded to it, but also I think in some ways have triggered that kind of funding, I think is actually very attractive, because it does mean that you bring cases to court where you are forcing corporate responses, which would not have been possible without that sort of a corporate investment in those cases. So geopolitics and trade, it'd be very much about security, it'd be very much about critical raw materials. Excuse me, we will be compromising environmental impact assessment in looking for mines in Europe. That's going to be inevitable. So the environment, you know, pur sang, will undoubtedly suffer, sadly. I said I was going to be optimistic.
Yeah. Maybe we can take another round of questions, and then you have a chance to give
To
an
turn it
optimistic
round.
answer. Yes. I can abuse my position as a chair to ask one question. So you are involved to quite a large extent in litigation, both in this country, but also in Europe. And you were talking about the litigation market maturing, and that's definitely something that we are seeing here. And I think the flurry of litigation is a consequence of that. But what is your opinion on the litigation scene in continental Europe? How does it compare to what we have here?
Yeah, it's a very interesting question. It's not quite, it's of course very, very different. And I also, by the way, appreciate that litigation in England looks very different for criminal law, right? I mean, there's a lot of, I think, justified hooray for English civil and commercial litigation. The criminal law scene, I understand, looks quite different. But having said that, so in the EU, it's always that some jurisdictions are much more advanced than others. The Netherlands is one, with a very mature litigation funding market. Germany, slowly so. In Germany, what you tend to have to do is dress up a claim as a consumer law claim, because then both the funding and the various standing requirements, etc., are much more easy than they are in other parts of the EU. So there's clearly shopping going on in the EU. And of course, there's also shopping going on between the United Kingdom and continental Europe. And last week, there was an announcement of new German civil procedure rules, which should facilitate cases being brought in English and so on in Germany, which I thought was a very interesting development. And Professor Roux has a very good summary of that on the Conflict of Laws blog, or the EAPIL, European Association for Private International Law blog. But I think what the litigation also shows, and this is something perhaps that I want to emphasize with the students in the room and online, is that very seldomly are these cases won by the sort of Hollywood type lawyer who bangs a statute book on the table, right? And somehow everyone has a moment of epiphany, and the judge realizes that she or he needs to save the world by issuing a certain judgment. That's obviously not the case. Most of these cases are won because the claimant's lawyers have the kind of detailed knowledge of the type of areas of the law which many students who have a personal interest in environment, sustainability, human rights, probably run a mile from. Insolvency, civil procedure rules, corporate law, director's liability, for instance. Private international law, crucial to quite a few of these cases. Also, indeed, as I suggested at the beginning, the interplay between these various fora, because some of you might have heard of investment treaty arbitration being a threat to the European green energy transition. that's not just because of corporations using energy treaty and other arbitration cases to try and get their claims. It's also because they try and engineer claims away from the European Union, get it heard in places like Dubai or Ruritania, and then try and have it enforced on assets in, let's say, Ruritania Plus. So there's a lot of sophisticated litigation mechanisms which, if one really successfully wants to address these issues, you should really dip into also, including as a student. And it all starts with tort law, of course. Right? So you must attend your tort law classes. You must attend your corporate law classes. You mustn't ignore insolvency, it would be my suggestion.
Well, Gerrit, thank you so much for coming here tonight to give this talk. I would like to ask the audience to thank the speaker with a big round of applause. And there are some drinks outside, so please stay. You'll have an opportunity to ask questions informally. Thank you so much.
Thank you.